Alright, so when it comes to getting injured on the job, there's a couple avenues for an injured worker to pursue compensation. One, which is the most common, is workers' compensation through the Bureau of Workers' Compensation. That's basically an insurance program run through the state of Ohio, and it's a no-fault system. Simply put, you're hurt on the job, you get compensation through the Bureau of Workers' Compensation. There's various types of compensation through that, but the general gist is you get hurt on the job, regardless of fault, you're going to get compensation through that system until you're good enough to go back to work. Another avenue is what's called an employer intentional tort, and this is a statutory claim. It would require a lawsuit to be filed against the employer by the employee, and it's codified in Ohio, codified in Ohio Revised Code 2745. And it's a short statute. I got it right here. It basically takes up a half a sheet of paper once it's printed out. And simply put, an employer intentional tort, an employee who is injured on the job can get compensation from the employer if the employer committed an act with an intent to injure the employee, or with the belief that the injury was substantially certain to occur. In the statute, substantially certain is specifically defined. So to prove substantially certain, the employee would have to prove that the employer acted with deliberate intent to cause the employee to suffer an injury, a disease, a condition, or death. So that's how substantially certain is defined in the statute. So as you can probably tell, it's a pretty high burden if you're going to pursue one of these employer intentional tort claims. You got a high bar to reach, and they're not always successful, but there are certain circumstances, and the statute itself actually provides two circumstances that provide a rebuttable presumption that the employer intended the injury. One circumstance is if the employer deliberately removes a guard from a piece of machinery. If there's a die or a press that has certain guards built into it to ensure someone can't get their hand smashed or injured in another way, if the employer deliberately removes that, there's a rebuttable presumption that the employer intended to cause the injury. And then the other circumstance that provides that rebuttable presumption is if the employer misrepresents the nature of a toxic substance or chemical. So those are the two circumstances specifically set forth in that statute that really help out injured employees if those situations apply. So what does this all mean when it comes to intentional tort? Well, I got a case just to provide an example, and this is out of the 9th District in Ohio. The 9th District has jurisdiction over 4 counties: Medina, Summit, Wayne, and Lorain County. So this case came out of Lorain County specifically, and it is titled Ryan Smith versus Ray Esser and Sons Incorporated. And the case number is 2013 Ohio 1095. And in this case, Esser and Sons is a commercial plumbing contractor. It was hired to repair a leaky fire hydrant. So the crew that day goes to the job, and the leak is underground. So what they had to do, they had to use an excavator to build a trench around the fire hydrant. It was about 7 feet deep. And Ryan Smith was one of the employees on the crew. Well, Ryan Smith was a high school kid. He was doing this job as an intern through one of his school programs. So this is the first thing he's doing on the job with this company. So they go out. I don't think he had any involvement in excavating around the pipe, but he was ultimately going to be the person going down in the hole to work on the leak. But before they can do that, they had a 2-day delay because they got some severe rain. Rain filled up the trench they built, or they dug, I should say, And so there was a 2-day delay. They come back after 2 days, and they have to pump out the water from the trench because it's completely full. So you factor that in with the fact that there's a leaky pipe, the trench is muddy, the walls are wet. But the foreman sends Ryan down there anyway, and what he had to do to start out is he had to use an electric hammer or sort of drill to chip away some brick that was around the leak. They had to do this to get to the leak. Well, after he does this and he's clearing out some of that debris, all of a sudden water starts rushing into the trench. The pipe comes loose, traps Ryan's hand against the edge of the trench. He's pretty much stuck in there as the trench is filling up with water. He's eventually able to get loose and get out of there. But what had happened is when the pipe came loose, went up against the side of the trench, got his hand caught, it tore a tendon and broke 6 bones in his hand. So Ryan then brought a suit against Esser & Sons, an intentional tort suit, because of that injury he sustained, saying that it was substantially certain that he would be hurt and that the employer knew this. So some of the circumstances surrounding this, the trench, the walls were pretty much vertical, parallel to the pipe going down into the ground. And in the case, the court identified some federal regulations that required trenches to have some sort of angle. When you dig those trenches, the walls have to be at an angle. So right there's a violation of a federal regulation. Federal regulations also require someone with experience to be there to oversee the operation. Well, the foreman on this case didn't have any training or experience with these trenches and dealing with water leaks. So again, there's another factor that sort of goes against the employer. It had come out that had the trench walls actually been at an angle, it pretty much would have been impossible for Ryan to get his hand stuck because there would have been more space, so that there wouldn't have been that injury. And there were a couple other factors. I mean, just the fact that we're dealing with a 17-year-old kid here who's on the job for the first time and didn't have the experience. You know, they probably should have had someone, you know, who knew what they were doing. And the employer pretty much admitted that they knew that they were violating these federal regulations. So those were some pretty big factors that the court considered, and in this case determined that it was substantially certain that Ryan would be injured, considering all those circumstances, the way the trench was dug, the weather conditions surrounding that time period with all the rain and the water and the mud, and just the lack of experience from the foreman and the employees there that should know what they're doing. And in that case, they ruled in favor of the injured employee. So, you know, even though these employer intentional tort claims are pretty tough, there are circumstances where they win, and it's very fact specific, but the remedy is there, and it's always an option to consider when you're injured on the job.